Bueno, muy buenos días a todas y todos. Eh, Estamos muy temprano en la mañana de un día jueves, 8 de la mañana, para conversar sobre la Cámara Regional Alemana, que es, en cierta forma, la inspiración o una de las fuentes de inspiración de lo que podría ser la Cámara de las Regiones en la Constitución chilena. Y para eso vamos o en el proyecto de Constitución más bien. Para eso vamos a conversar con el profesor Rüdiger Wolfrum, que es profesor de la Fundación Max Planck en Alemania, que está de visita en Chile y que con él vamos a conversar de la experiencia que él tiene con esta cámara. El profesor Wolfrum es un activo y destacado jurista alemán que tiene cátedra en la Universidad de Hamburgo y que ha trabajado en una cantidad enorme de temas, incluyendo, por supuesto, el derecho constitucional, derecho internacional, derecho humanitario internacional, derechos humanos en general, el derecho del agua. De hecho, el presidente Wolfrum fue presidente de la Fundación Internacional del Agua. Es decir, tiene una vasta visión del mundo de las leyes y, por lo tanto, con él podremos entender un poco más cómo funciona esta Cámara y qué lecciones se pueden sacar para el caso chileno. Pero el profesor Wolfrum, desgraciadamente, no habla español, habla alemán, por supuesto, su lengua nativa, inglés y francés. Entonces vamos a hacer un cambio hacia el inglés y ustedes podrán tener los subtítulos abajo en la grabación. So thank you very much, Professor Wolfrum. It's still not 8 o'clock here in the morning. We are starting really early. Thank you very much for your kind acceptance of this call. I was telling our public that the Chilean Cámara de las Regiones, which is one of the proposals made by the Constituent Assembly, is based to some extent on the German Bundesrat. So we would like to understand a little bit better how this chamber works, which are the powers that this chamber has. So eventually we could start. Why don't you explain us briefly how the Bundesrat is composed? What's the link with the Länders? Länders is the German word for regions or states, indeed, because it's a federal country. Could you explain us a little bit how does it work and the broad powers it has?
Sure. Germany is a federal state, and Chile is going to be a decentralized state as one can take it. But the difference, every federal state is also a decentralized state. Therefore, the Bundesrat is very typical for decentralized or federal states. It represents the Länder, as you said yourself, the states as we call it. Germany is composed of states. These states have their own government, their own assembly, their own executive, and that's the difference vis-a-vis decentralized states, their own constitutions. These constitutions have, however, to be within the framework of the basic law, which is the German national constitution. Now, when the basic law was adopted, it was discussed as you discuss it here, what should be the function and how should be the Bundesrat, the Federal Council in an English translation, be composed. There were several ideas lanced, for example, also the idea of a kind of a Senate and of the American system. But finally, it was agreed upon that the Länders, the states, would have a direct representation at the federal level. This says that we chose this system had historical reasons. For the Bundesrat existed previously, and it represented under the imperial period the governments of the states, to be exact. the governments of the various kings, princes, etc. Now, the composition of the Bundesrat is very simple. All states are represented in the Bundesrat, and they are represented by a person, by the prime minister, first of all, or he may be replaced by one person from within its cabinet having ministerial rank. Therefore, the Bundesrat is nothing else but the representation of the government of the Länder. This has a following consequence. Since the composition of the Bundestag depends on elections, and the composition of the Bundesrat depends on the governments of the Länder, the two are not matching. We have very frequently, actually most of the times, the federal government has to deal with the Bundestag, the House of Representatives, its own color, but maybe with the Federal Council with a different color, so to speak, political color. Now, our states are quite different in size. They range from 0.5 million, this is Bremen, 500,000 inhabitants, to something like, I believe, 17 million in Austria-Westphalia. This is not totally reflected in the composition of the Bundesrat. It is, however, to a certain extent, mediated, if you wish to use that word. The bigger Länder, such as Bavaria, Austria-Westphalia, Baden-Württemberg, have 5 votes in the Bundesrat, and Bremen, Saarbrücken, Hamburg only have 3. But the discrepancy between 0.5 million inhabitants in Bremen and 17 million point something in Northern Australia, between 3 to 5 seats, is evident. Therefore, the composition of the Bundesrat favors the smaller Länder. But this is not particularly relevant, for although Baden-Württemberg and Northern Australia have 5 members, they can only vote with 1 vote.
So may I ask you something?
Sure.
So you say that each Länder's prime minister is represented, but the chamber is larger than that. You have more representatives. Who are those other representatives?
No, there are no other ones.
Okay.
These are only the members of the cabinets or the governments of the Länder, nobody else. And therefore, the voting has to be unique. Sure, when the voting comes, Bavaria counts 5, but it's always 1 vote.
Okay.
You see the problem?
Okay.
The weight of the vote of Bavaria, Baden-Württemberg, and Northern Westphalia exceeds the vote of Saarbrücken, Bremen, and Hamburg, since these are 5 votes each, and the others are 3 votes each. But there is one element. The government of the Länder is represented as one. Now, since most of our governments, including on the Länder side in Germany, are coalitions, what is going to happen if we have, for example, in Northern Australia at the moment, the prime minister is CDU, and however, he is in a coalition with the Liberals. It may be that the CDU and the Liberals, since the Liberals are in the moment in the federal government and the CDU is in the opposition, they may disagree. Maybe, doesn't necessarily matter. Nevertheless, they have to give only 1 vote, can't split their vote, and therefore, since the prime minister is the one who so to speak, is dominant, the vote will be along the CDU line, and the FDP will not bring through its voices in the Bundesrat.
Okay. Now, the
last sentence, this is a matter which polarizes a little bit the sentences, the opinions in the Bundesrat, makes life for the government, federal government, much more complicated.
Okay, of course. Now, precisely about this, the biggest concern we have here is to what extent this regional chamber or the Bundesrat should review laws that are being discussed in the lower chamber. So, and this is the biggest issue, I would say, more than the composition. This is more or less out of question. But to what extent do you think that this chamber? Well, explain us a little bit. How does it work in Germany? You explained me that there was a kind of mismatch between the formal powers that the Bundesrat has with respect with the actual powers, and that in fact the review at the Bundesrat level is much larger and much more important than what is in what the Constitution says, basically.
I come to that, and we distinguish according to the Grundgesetz between laws where the Bundesrat has a veto and laws where he has only a temporary veto. I'll explain that in a moment. There are certain laws, and this has been set out in the Grundgesetz, in the basic law, which require the consent of the Bundesrat. These are very few, if you go to the specificity. But the rule is, however, that whenever the law infringes within in the competences of the Länder or one particular land, then the Bundesrat has a veto, or the Bundesrat is required to consent. Now, you should know the system in Germany. In the German system, the legislative powers rest with the federal level, and the executive powers rest with the Länder. If you ever come to Germany, you come in contact with one federal executive border control, and apart from that, only embassies are executive powers on the federal level, and I don't hope you come into contact with the army. This is the other element. All the other executive powers are powers of the Länder. This is not always well understood. Now, if the law says, that I explained to you in our brief interview in advance, changes a provision in our civil code. Civil code is governing the relationship between individuals in Germany, contracts, lease, and whatsoever. This law will certainly go to the Bundesrat, but it has no particular impact upon one of the Länder, and therefore the Bundesrat can only say stop, and then give the reasons, and then the Bundestag has to decide again, and that's the end of the matter.
Okay, that's the temporary veto.
That's the temporary veto, and it is not being exercised very frequently. If, however, the consent of the Bundesrat is required, then this is what I said. The law cannot come into action, to put it that way, unless the Bundesrat says yes. And for that, we have a particular committee. In such a case, there is a difference between the Bundesrat and the Bundestag on such a law, then they have to establish a mediation committee. The mediation committee is composed by members of the Bundesrat and in equal numbers from the Bundestag the chairmanship rests with somebody from the Bundestag.
Okay.
And they have to overcome the divergent views. They come up with a compromise, they have to. And this has to be accepted by the Bundesrat and the Bundestag. If it's not accepted, that law failed.
Okay. How often has this happened?
Let me put it this way, in two stages. It doesn't happen that a law failed is rare.
Okay.
I can't remember it in the
The
last...
mediation committee works.
The relation committee works perfectly well. Next point is, how many laws go in this relations committee? Quite a lot.
Okay.
This is due to a practice which was not anticipated. It was expected when this particular rule was drafted that perhaps 10% or not more than 20% of the laws would need the consent. But now, due to the higher complexity of laws, very often new laws contain institutional arrangements. And since the institutions are the dominance of the lender, therefore more and more laws require the consent of the Bundesrat. Let me give you a recent example. Health is actually a federal matter, but the protection against the pandemic requires the establishment of certain institutions. And from that point onwards, you need to have the consent of the Bundesrat. If you have read the newspapers this morning, it's a lousy example, but it is an example. The federal level wanted to establish the obligation to be vaccinated.
Okay.
Sure, the Bundestag has rejected that idea, but if it had accepted it, as such, it would have not required the consent of the Bundesrat, but there was another element in it, namely to establish a register for vaccination. This requires the action of the lender, and therefore this would have needed the consent of the Bundesrat. It's a non-issue in the moment since the Bundestag didn't adopt that law, but it could have been stopped also in the Bundesrat if it ever had come to the Bundesrat. In this case, the Bundesrat was not involved at all. Therefore, if you do such a system in Chile, you must not only copy the two institutions, but it is mandatory to also provide for this mediation committee. It's already contained in the American system.
Yeah, it is being considered that it's quite often in the actual Chilean parliament, we have quite often when there is a disagreement between the two chambers, there is a committee specialized, a mixed committee it's called, which is intends precisely to reach an agreement on the thing. So that's...
Therefore, you have already the practice, and therefore to get used to this practice is easy for you.
Yeah. Well, another question: do the Bundesrat or does the Bundesrat have any capacity to initiate a law?
Yes, the Bundesrat has that capacity. It doesn't happen that often. According to the Grundgesetz, the initiative to enact a law is with the federal government out of the first chamber. So you need for that 10 or 15 members of parliament, and from the Bundesrat. If there is an initiative from the government, it has to be sent to the Bundesrat first, strangely enough, and from there it goes to the Bundestag, then it goes through the 3 readings and goes back to the Bundesrat, etc. If the initiative comes from the Bundestag, it gets its 3 readings, the federal government is informed, and then it goes to the Bundesrat with a view whether the Bundesrat accepts or doesn't accept. And if the initiative comes from the Bundesrat, then it goes to the federal government. The government has a right, rather the obligation, to comment upon it. Then it goes into the Bundestag and the traditional course through the Bundestag. The reason why we have this way, the federal government should always be informed what's going on. That's evident. And the first say is with the Bundestag, and therefore it always ends in the second step already in the Bundestag. The initiatives exist. I wouldn't say they are very frequent, but they are not that rare. Okay. There is, however, a small issue. If you have listened to me, the initiative from the procedure for initiative of the federal government is rather complicated. It has one step more. And therefore, occasionally, the federal government hands over the law to a member of the Bundesrat, and therefore, to a certain extent, cuts out 2 or 3 months for deliberations. It's considered not proper, but it's not unconstitutional.
Perfect. Okay. It's a practice, regular practice. Okay. Okay. So
let me add one thing. The Bundesrat has committees, as the Bundestag. Yeah. Our parliaments work very much through committees. And these committees in the Bundesrat are very much organized or depend upon the government of the Länder. That you should take into consideration. Whereas with the Bundestag has committees which mirror the ministries. And there's a strong relationship between the Bundestag and its committees to each ministry. We have a committee on, let's say, foreign affairs, which is in contact with the Ministry of Foreign Affairs, etc.
Okay. For example, the budget, is it discussed at the Bundesrat level, or is a federal matter only?
No, this is discussed at the Bundesrat level. By the way, what I didn't mention, very hard to understand, don't refer to the Bundesrat as a second chamber. It is not the second chamber, it's an organ of itself.
Okay.
Yes. And what you should also know, the president of the Bundesrat replaces the federal president when he or she is absent. Therefore, the president, that's a rotating business. The Länder are rotating in a six months term to become president of the Bundesrat. And this person is number 2 in the protocol hierarchy of the Federal Republic.
Okay, okay, perfect. Okay, so the president of the Bundesrat is not chosen; it's a rotation of the between the Länder's president, prime minister.
According to the German alphabet.
Okay, okay, excellent. The term of so if I understand well, given that there are prime ministers of the Länders who belong to the chamber, the term is undefined because it depends on the elections at the Länders level.
Yes, it depends on the elections in the Länder. It's a permanent organ, and there's always a permanent president, and that is the reason why the president of the Bundesrat replaces the president of the Republic.
Okay.
For you always have a president of the Bundesrat. There cannot be a vacancy.
Okay, but okay, sorry. Okay, perfect. Can I ask you about the moving? I'm not sure whether I have another question concerning the Bundesrat, but there is another matter which is also important for us, and it's at the federal level. It's for the Bundestag. So we may eventually move to the other chamber, to that organ, as you say. it concerns the limit on federal representation for political parties. So you have this 5% limit.
Yes.
So smaller parties that do not reach 5% do not reach any, no?
That's a common view, but it's not the correct view. It's
Okay.
5%, or if the political party, it was the last time the Linke, the communists, they didn't have 5%, but they have 3 direct mandates. Our electoral system is a proportional system as well as a direct system, mandating system. And since they won 3 districts, they are in the Bundestag, but not only with these 3 votes, but then they get proportionally what they had gained under the proportional election system. I hope I better explain the electoral system. We have, a German has 2 votes. 1 vote, the first vote, is a vote on a candidate in the district, the counting district. And here, he or she needs the majority, not an absolute majority, the majority counts, maybe 36% or whatever. And then there is a proportionate vote, the second vote, and here you vote for a political party. Not, there are lists where the political parties put on their candidates, and these lists are for each state. Therefore, if you are elected directly, you are taken from the list. Therefore, first, the Bundestag is being filled by the direct votes, and then one looks at the list, how many additional seats the party will get on the proportional system. The problem is, particularly in Bavaria, there is a CSU who mostly gets every district, and therefore has, under the proportional system, too many seats in parliament, and this is equalized by adding to the other parties additional seats. But that is on the electoral system. Now, if you have 3 seats already, you get your share, and the Linke therefore was represented in the Bundestag with its share.
Okay. Yeah. Do you believe that this has helped in avoiding fragmentation of the German political system?
As you can see, not fully. We have plenty of political parties. This has something not so much to do with the electoral system, but with the changing view concerning elections or political parties in the population. Let me put it this way, the confidence in political parties has gone down. There is more interest in new political parties, in the Greens, in others, and therefore this, under the present cabinet, Scholz had something like 30 plus votes. It's not a majority, it's far off, and therefore we often have, or in the recent past, mostly have coalitions, which is actually not bad. But it would be better if we had not such a big fragmentation. We have this big fragmentation in Germany since the last, not the last election, but the election before. But if you look at the ballot sheet, it excludes the last ballot sheet I had to vote on, contained for Baden-Württemberg, I believe 36 or nearly 40 political parties, from the Green Panther to the group of lesbians and so on. Or
and the Pirate Party was...
The Pirates, they are better known, but we have very strange configurations.
But at the end of the day, how many parties do actually get, for example, currently, how many parties do you have representation in the Bundestag level?
This is in the moment SPD, the strongest. The CDU and CSU as the second strongest. The Greens, the Linke, the leftist, and the, I should have gone differently, and the AfD, the ultra-right. And what you might not know, one independent, that is a representative of an ethnic minority in northern Germany, ethnic minorities which have their own, so to speak, party, are exempt from the 5% clause.
Okay.
That might be an element.
There's only one seat for them.
No. They are exempt from the 5%, and there could be as many as there are. But we don't have that many ethnic minorities. We only have the Danish minority in the northern part of Germany, and the Serbian minority, which is in the east. There is also recognized a Frisian minority, but they will never make it. It's very limited. I believe that, and we have the Jewish don't want to be called a minority, therefore they don't consider themselves in that. And the Sinti and Roma are not numerous enough.
Okay.
And perhaps there is no doubt about it. We have perhaps also a Polish minority. Ethnically, we have that, but it is a question how they consider themselves.
Okay.
Traditionally, it's only the Danish minority, and the rules governing them is being based on the basis of an exchange of letters between the government of Copenhagen and the government of, in that case, Bonn, later Berlin. And this is due to the separation, to the drawing the northern border between Denmark and Germany. It's an established system. If you ever come to Germany, go to Flensburg, there you will see the street signs, etc., in German and Danish. The relationship is perfect, absolutely no problem. And in Schleswig-Holstein, one member of the Danish minority sits in the government.
Okay. Excellent. I really don't have much questions because our main concern is the Bundesrat, and we wanted to confine this, so I get tempted to ask you about the 5%. Do you think after being, I know, let me ask you, we can extend a little bit, let me ask you this, about the constitutional review. Because we are concerned about the equilibrium of powers here. So in the German system, you have therefore laws which are being discussed at the Bundestag level, which may come or not to the Bundesrat for review as well. Therefore, you have some counterbalance there. But you have a very powerful constitutional tribunal.
Yes.
Can you explain us a little bit when this tribunal takes action in a law that is being discussed?
Yeah, sure. Different from what has been the practice or the law in Chile, the Bundesverfassungsgericht, the Constitutional Court, as we call it, takes action only after the law has been passed and not before. This is a distinction between a constitutional court and a constitutional, council, which is giving advisory opinions. The Bundesverfassungsgericht has no right to give advisory opinions. That's it.
Okay.
There are a couple of procedures how the Bundesverfassungsgericht gets in. The most important, dogmatically important procedure is what we call the abstract normative control. Upon the initiative of 25% of the Bundestag or one state and or the federal government, they can initiate an assessment of that law at the Bundesverfassungsgericht. There is not much more cases than one, maximum 2 per year. But that is a very drastic form of control. When the Bundesverfassungsgericht comes to the conclusion that this law is unconstitutional, then the judgment is publicized in the Gazette, and this judgment has the status of a law of parliament. Therefore, you have no problem of being why this works, etc. In this case, the Bundesverfassungsgericht replaces the parliament and saying this is null and void. And this is binding on everybody and every institution.
Sorry, but the matters that may be considered unconstitutional by the will they be replaced by, will be changed or reformed by whom? By the Bundestag?
In such laws, the decisions, I should rather say, often the Bundesverfassungsgericht gives some guidance how the law should be done.
Exactly.
Yes. For example, when it came to the very much early in the history of the Federal Republic, the equality between men and women, we were traditional priority for men. The Bundesverfassungsgericht declared how the law should be done. It went quite into details. The second possibility is as follows. If in a conflict between a citizen and another citizen or whatsoever, the court comes to the conviction that the law it has to apply is unconstitutional, the case has to be suspended, and the court in question will place a question to the Constitutional Court whether this law is constitutional or not. And only thereafter, the case proceeds. That's Article 100 of the German Constitution. Okay. This ensures that no unconstitutional law would be implemented. The third option is what is a more indirect option, and these are the majority of cases, that any individual, including foreigners, can bring a petition to the Constitutional Court arguing that, indirectly mostly, that a law is unconstitutional. Why do I say indirectly? These individuals complain about an act of the public authority. Okay. The ones act on the basis of a law or on the basis of an order, which again is to be based on a law. And here, this can only be done in most cases after having exhausted the remedies provided for under Article 19, paragraph 4 of the German Constitution. But there comes also an indirect assessment of the law, which is on the basis of that claim, whether it's constitutional or not. The lack of constitutionality can be a substantive one. The law violates a particular norm, mostly equality, or there is a violation of a certain procedure in enacting the law. These are, or there was a lack of competence. For example, several years ago, the Bundestag issued a law against smoking in restaurants. Sounds straightforward. The restaurants of a particular size who wanted people to allow people to smoke would have to have a separate room where they could smoke, but there was no possibility to mix smokers and non-smokers, and it was not so easy to establish restaurants where only smokers could go. Sounds perfectly all right. This law was considered on the basis of an individual complaint unconstitutional, for the federal government has no competence to do so. Now, what is the question? The question was this law a question concerning health, an issue? Then the federal government would have had the competence, or was this an item falling under dealing with restaurants, bars, and so on? This is evidently a matter of the Länder. The Bundestag had, in all its enthusiasm, overlooked that possibility, and therefore the law was unconstitutional. was kind of a shame.
Okay, that's interesting. In Chile, we have this abstract review of constitutional review, which has been very controversial in the past, because this review takes place once a given number of members of the Congress ask the Constitutional Tribunal to take a view of the law. But the weird thing is that the Constitutional Tribunal itself, they make changes to the articles, and then the law comes into effect without a further democratic review. That's very weird. We have really cases in which the Constitutional Tribunal has done exactly the opposite of the democratic decision, without allowing the democratic representatives to the chance to change or to review or to react to their views. It's very, very weird. Okay.
I give you an example of a very recent decision of the Constitutional Court on climate change. It was, when was it? In March last year. It's rather recent. The complaint was by individuals, partly by individuals from outside Germany, who claimed that the German Act on climate change was unconstitutional, violating their rights, since it would not protect their rights from 2030 to 2050. The Act only dealt with the period up to 2030 and left everything open for 2050. Here, the Constitutional Court declared this law partially unconstitutional, but it did not say what the Parliament should do. It only did say the Parliament shall cover the period from 2030 and 2050 in a way they considered appropriate. That was not an infringement. It only said you left a gap, fill this gap as you feel. This has been done, no problem. Mm-hmm. However, I give you another case, which may be also controversial or would be controversial in Chile, the question of abortion. Abortion was strictly prohibited at a certain point, and there were some minor, moderations in Article 218 of the Criminal Code. And here, the Constitutional Court made a ruling saying that abortion was illegal as such, but should not prosecute it if undertaken under certain conditions. From a point of law, it's an absolutely lousy argument, mm-hmm. but it was also a compromise. Mm-hmm. Very much discussed, but here again, it left the whole issue, the provision intact, but gave an interpretation which was not contrary towards the Bundestag, the first chamber had said. But that is a very thin line. Dogmatically, you can justify that by saying, in former times we said Parliament can do no wrong. We now know, as a matter of reality, that Parliament can definitely act illegally for the one reason or the other. And here, the Constitutional Court is upholding the rule of law. And this is one of the pillars of a modern constitution, having rule of law and being a democratic state. Both principles should be fully implemented. And the Constitutional Court are the guardians of the constitutions.
Exactly. Do you have any and we can end with this because you need to go to another meeting, but the alternative, because we have this tribunal, the Constitutional Tribunal that was created in 1970 before dictatorship. But some people is now suggesting that this should be replaced because it has it's a bad reputation, our Constitutional Tribunal today. It should be replaced by a sort of American system in which the Supreme Court takes over the challenge of interpreting the Constitution. Do you have any view on that? Do you see any?
You may consider me biased. I come from.
I presume. But
therefore, deduct from what I'm saying that I'm biased. But I believe we should take into consideration that interpreting the Constitution and judging on the basis of the Constitution requires a different type of judge. A judge who has also a particular legitimacy. Therefore, this is important that this really fits. The German judges for the Constitutional Court have to be appointed or selected by one part by the Bundestag and the other part by the Bundesrat. They require, in both cases, it's a rather complicated procedure, a 2/3 majority in that particular chamber or institution. Therefore,
2/3 in each.
2/3, not the ones selected by the Bundestag, they need 2/3 in that one, okay. And the Bundesrat, they have 2/3 in the other one. Actually, okay. The practice is for the Bundestag, there is a chamber dealing with that. For the Bundesrat, it's a full Bundesrat, but that's a detail. Now, this is, however, not all. In the moment, no, there is one further rule. We have 16 judges, 8 in each chamber, strangely enough, even numbers, but it works so far. And 3 in each chamber of the Bundestag, I didn't say the Bundesverfassungsgericht, the tribunal is divided in 2 chambers. They hardly ever sit together, they mostly sit separately. And in each of these chambers, there have to be 3 judges from the Supreme Courts, plural, for we have a Supreme Court for civil matters, criminal matters, labor law, whatsoever, social law, for example, and administrative law. 3 in each must be, so to speak, professional judges. The others are, in the moment, mostly coming from the academic world. We have had.
Are they chosen one at a time, or they're chosen by packages?
No, they are chosen one in the time. They have a term of 12 years, which cannot be renewed. They only serve one term, end of the story. Okay. And they are chosen whenever there's a vacancy. Therefore, we have a kind of a rotation in the chambers, which makes life a little bit more complicated for the court. In March, one of the prominent members of the first chamber, a professor in Göttingen, had to resign or went into pension, etc., although he's younger than I am, much younger. Be it as it may, if you look upon this selection process a little bit behind the curtain, then you see that there is a huge interchange of views between the political parties who should become a judge, and more importantly, who should become the head of one chamber, the head of that maybe vice president, or the other chamber, the president of the whole court. Therefore, the members of the Constitutional Court reflect more or less the whole spectrum of the political spectrum in Germany. There has never been, to the best of my knowledge, somebody from the AfD, and there will never be one, for they are not included. And there have been only one somebody who was slightly affiliated with the left. Therefore, that's important. The reputation of the German Constitutional Court is fantastic. Absolutely. Better than the reputation of the government, the parliament, and whomsoever. Perhaps we Germans are law-abiding people. That may be the reason.
Yeah. Unfortunately, we don't have the same situation here. It has been really sad to see how the reputation of the court has been diminishing over time. It's very
in
sad.
most countries of the world, and the majority of countries in the world have no constitutional courts. And if you don't want to rely on the German system, look into the South African system. They have a very active, very modern constitutional court. The jurisprudence of this court is perfect, and the reputation of that court is fantastic.
Okay, we shall see whether we can do so many things in such a few time. We are 3 months away from finishing the project, so we don't have probably time to look at the South African experience, but the German experience is very, very interesting. So, Professor Wolfrum, I really thank you very much. Danke schön.
Ja, ich bin gleich fertig. That was my colleague who wants to take me to the other meeting.
Yeah, I presume. Thank you very much, and I wish you all the best in your trip way back to Germany.
Thank you very much indeed. It was a pleasant exchange of views, and we can do it again if you wish. The modern technique, a Zoom meeting works across the continents easily. Thank you very much.
Thank you very much.